Good afternoon, everyone. My name is Laura Bacchus, and I'm the Director of Dykema's Automotive Industry Group. Welcome to the first session of our 2026 Dykema Drives webinar series. Our first session has garnered quite a bit of excitement. We have about 80, 90 folks signed up. What to do when the government comes knocking. Here's some information you'll see about how to obtain CLE credit. This will be emailed to you after the fact. And if you have any questions, feel free to reach out. If you're not familiar with Dykema, I'd like to just take 30 seconds and tell you a little bit about the firm. Dykema is a national law firm with offices in automotive industry hubs like Detroit, Los Angeles, Dallas, Washington, D.C., and throughout the Midwest and the industrial cities. We do have a full breadth team, about 140 attorneys focused on the automotive industry out of our 400 attorneys total. The services we touch are pretty much anything that you would need in the automotive industry, from antitrust all the way to EAV, to government investigations that we're talking about today, supply chain, and everything else. People come to Dykema because we have attorneys that know the automotive industry. You'll find some additional information today in the PowerPoint that goes out. One would be our Automotive Trends Report, which we're getting ready to publish. This is a result of our survey, which identifies the top 10 legal issues that the industry is faced with this year. You'll also learn a little more about our 4th Annual Automotive Legal Summit. This is a legal summit held in Pontiac, Michigan each summer, focused on the topics that are important to you in the auto industry. And with that, I'd like to introduce our presenters. We have 3 presenters today, all former U.S. attorneys in management positions. One of our first presenters, Jennifer Beidel. Jennifer is the leader of our business litigation practice group here at Dykema. She's in our Bloomfield Hills office, also a former federal prosecutor and commercial litigator and government investigator, white-collar defense attorney today. Next up, Mark Chutkow. Mark is from the Detroit area, also in our Bloomfield Hills, Michigan office. Federal prosecutor that led the criminal division in the Eastern District of Detroit. He has some very high-profile matters focused on the automotive industry. And finally, we have Sarah Douglas. Sarah is resident in our Dallas office. Sarah has tried over 85 jury trials, as well as dozens and dozens of appellate briefs throughout her career in both the federal courts as well as the DA's office in Texas. And with that, I leave this to Sarah Douglas to start our presentation.
Thank you so much, Laura. And thank you all so much for having me. I'm really excited to be here for the Automotive Industry Webinar Series. And so we are here today to talk about what to do when the government comes knocking. But to know what to do when the government comes knocking, it's first helpful to know why the government may come knocking. And there could be a lot of reasons for that. The government has its hand in a lot of different areas, right? So any industry, and the automotive one is one of them, that is subject to regulations. Then you're going to have regulatory agencies that may have an interest in your company. There could be civil investigations, there could be criminal investigations. We've seen a lot in the news and in the field of immigration enforcement, or law enforcement can just come for courtesy without any legal justification for being there, but they can say, hey, willing to talk to us. When we're talking though about a dawn raid, which is more geared, what our presentation is aimed at, we are talking about when law enforcement generally shows up with some type of legal authority to be there. And so when it's a criminal investigation, we're generally talking about search warrants. There are certain immigration reasons that they could show up. And I think Mark will talk about that later on. But they may come to serve a subpoena. They may request evidence in some kind of investigation, executing some type of arrest warrant, or like we mentioned before, a dawn raid, and we'll get to why we call it a dawn raid. So, and depending on why the government's coming will depend on who's coming. It could be Department of Transportation, you could have the Federal Bureau of Investigation, it could be Homeland Security investigators, Customs and Border Patrol, it could be the IRS, just depending on what the investigation is and what they're looking for and what type of investigation will dictate who may be showing up that you may be interacting with. So dawn raids is more the focus of what we're here to talk about today. And we call it a dawn raid because most of the time it's going to happen first thing in the morning. And when we're talking about a dawn raid, what we're talking about is it's a very coordinated coordinated effort among law enforcement. And so before they ever get to your door, they have gotten together and they have an operations plan. They have coordinated who's doing what once they're inside, who's talking to who's looking at the computers if they're there to get into computers, who's gathering physical documents, who's taking photographs. So it's a very coordinated effort on their end. And they're generally going to show up unannounced. And they're doing this because there's a benefit to the element of surprise, right? They want to see what information they can get without you having had the benefit of preparation to either organize or know if you're going to talk to law enforcement, if you're not going to talk to law enforcement, or have some kind of plan in place. If it is some kind of coordinated effort, it's also possible they're showing up to more than one places at once. Like if you're a company that has multiple offices, they may be showing up at multiple offices at the same time. If they're looking at an individual target or an individual may be involved as well, they could be showing up at your office and at your home. And so they really try to take advantage of the element of surprise when they choose when to arrive and who all to go to. Oftentimes, it's also the last step of an investigation. And the reason why is because to even get in the door and have some kind of lawful authority in order to search and obtain and seize any kind of documents or what they may think is evidence from your facility, they're going to have a search warrant generally, which means they have shown a judge that facts justify the judge allowing them to search your facility. And so they will have gathered evidence leading up to it in order to get into the door. So one of the things that could include that would be a whistleblower. And I'm flagging that for the next step of how to prepare. But I want you to know it could be the end of a criminal investigation, and they already have a lot of information that they're already aware of. And so it could be reactive. Generally speaking, it's going to not be reactive. It's going to be part of a coordinated effort after having already done quite a bit of an investigation on their end before they ever go into the door. And so once they're in the door, what are they looking for? Either they're going to want to talk to certain people. It could be a certain list of employees. It could be just whoever that may be around to see who's willing to talk to them. They may have particular areas of your facility they want to look at. They may have certain items they want to seize, either documents, computers. So what they're getting once they're in the door is generally targeted in those three areas. And there are some things that you could do to try to protect yourself against dawn raids. And a couple of the biggest things are a strong compliance program. We talked about it could be a regulatory agency that's coming in for regulatory concerns. The more you have a compliance program that you have a policy, you abide by the policy, you train on the policy, those are real positive steps in order to make sure that you are protecting yourself against the government coming to your door. Similarly, regular internal audits, those go with compliance programs. And I mentioned before that it could be the result of a whistleblower. Whistleblowers, oftentimes if you give them the opportunity to be heard and have their concerns addressed, they're not going to go outside the agency. So if they have a hotline or a channel that they can go through to address their grievances, it may be resolved before it ever gets to a government agency to show up at your door. So a few things, those are just a few things you could do to try to prevent before you ever get to one.
Okay. So if in the unfortunate circumstance that you do have a dawn raid, there are some other preparatory steps that ideally you would take. And so the rest of our presentation is going to talk about what those preparatory steps should or could be. We're obviously not able in this kind of context to give tailored legal advice for your individual workplaces. And so we just want to talk through the kinds of things you should be thinking about. And then, of course, on policy fronts, there's lots of different variations and ways to do that, which we'd certainly be able to be willing and able to help you figure out what is the right specific policy to have for you. So preparation is really key. I'm going to talk through each of these things in a little more detail, but you should ideally have response policies that tell your employees what a dawn raid is at a high level, provide step-by-step instructions for those frontline employees that are most likely to interact with law enforcement officers. That might be reception staff, maybe it's security personnel. It just depends on how your facilities are set up. And then establish an escalation process. Who needs to know when law enforcement is present? How are we going to communicate that about that internally and externally? The policy should provide instructions for managers and legal who might be contacted as part of that escalation process. And then talk to IT employees about requests for records that generally come as part of a dawn raid. Taking a step back, when agents get there, they're likely looking for documents and information that could be hard copies and it could be electronic. In 2026, it's, probably 95% electronic, but if you have hard copy records, they might be looking for that too. And then they're likely going to ask to speak to some employees. So we've got instructions for IT on dealing with that request for records, and then guidance for witnesses on how to respond to interview requests that might come from law enforcement. And then, of course, policies are only worth the paper that they're written on if you don't train employees on what to do in response to that. So we need training on those policies as well. Then going through each of those in a bit more detail, focusing on that first line of defense, the first contact person first. Reception and security staff should ideally be trained on those policies we've just talked about to stay calm and professional, to de-escalate the situation, not to escalate the situation, and to get a couple of key bits of information from that law enforcement. You want the agency name and the person's identification. That might be a badge. It might be some other form of identification for different agencies. You want to see what legal authority they have or don't have to be there. It might be a warrant. It might be a subpoena. It might be something else. Mark's going to talk about that in a little bit more detail. You want those first line of defense folks to follow your escalation policy by notifying legal or whatever your designated response team is that agents are present as soon as possible. If you do implement company policies that restrict access to areas or records without, say, involvement of legal or involvement of someone in IT, you want those first line of defense folks to be ready to inform law enforcement of those policies. Of course, the highest bit of guidance is making sure your employees are always safe. And so we would have them explain what your policies are. But if law enforcement is demanding to go somewhere, demanding to access something, a policy isn't going to prevent them from doing that. And so the first line of defense folks need to understand that it's sort of a fine line they're walking where they're explaining any restrictions to law enforcement. But if law enforcement insists on doing something, they should respectfully cooperate, but not provide consent for the folks to do something more than what they're legally authorized to do. A key thing there to think about is, are the law enforcement officers asking permission to do something? If they're asking permission, we don't grant permission. But if they're demanding to enter, they're demanding to see documents, talk to someone, whatever it is, if it's a demand, then you don't want employees really at any level to be giving that consent, unless, of course, there's a consultation with legal and legal is directing that. And then when the agents enter the facility and go away from that sort of first line of defense person, someone should be identified to accompany those agents into the facility. That helps make sure that things are under control, that, you know, folks in the facility are not caught off guard by the fact that law enforcement is there, and that person can also document what happens. What records do the law enforcement agents ask to see? What did they take? Who did they ask to speak with? All of those things can be done by the person who accompanies them in the facility. So then you also need an escalation process. You should think through for your individual company and set of facilities, who needs to be contacted and in what order, and lay those folks out in a policy with their contact info so that they can be quickly contacted. Some companies have little cards, like the size of a business card, that might have that contact information and a couple of key steps on it. Some have a rapid notification phone chain. You know, all of those options are fine, but whatever it is needs to be decided carefully and implemented. An important aspect of that is who is going to message within the company about what's going on, and who's going to be designated to do outreach or PR if it's something that's highly public. I'm sure you've all seen on the news situations where law enforcement is videotaped by the media outside of a company. In that situation, you might need PR, and someone needs to be designated to deal with that. And of course, the escalation process should coordinate all of that, you know, between legal and the communications team and whoever else is in play. So then you've got that first line of defense. They follow the escalation process. Now it gets to managers and the legal team, whoever you've designated as part of that escalation process. So in that process, the people who receive the escalation will need to be prepared to answer a set of questions and deal with issues that may arise. Again, there's many potential answers to these questions. There sometimes are not right or wrong answers. It's just something that each company has to decide what's best for them in this particular circumstance. So some companies decide that if there's this kind of a raid, we're going to close operations, we're going to send all employees home. That could be a policy standard. Others say our operations are too important, we can't lose the money for the day of sending employees home, so they don't do that. Or sometimes there's a mix. Maybe you have essential employees that stay on and others are sent home. You don't have to have employees stay there once law enforcement comes. You can permit them to go home, but again, that's something that each company needs to decide with counsel about, you know, what makes the most sense given their operations. You also should think through how you would go about reducing the impact that law enforcement's presence might have on your workplace. So some companies say, we're going to provide a separate conference room workspace if law enforcement comes, and put them in there. And if they request documents or electronic systems access, you know, we'll bring in a laptop, or we'll bring in IT, or we'll bring in documents, whatever it is. That helps minimize, or can help minimize, the impact on the workplace, you know, as opposed to having them sort of wandering around office to office or on a manufacturing floor or whatever it is. Other facilities don't have that option. And so maybe the choice is made to, you know, you're going to escort them around the facility in whatever way minimizes the impact. Sometimes law enforcement also hands over a grand jury subpoena during a raid. So they're going to try to get as much information as they can during the day they're on site, but they very well may have things that they were unable to get, or things that they want to follow up with the company on. So something that can be done is you can have in a policy a statement that, you know, legal is going to reach out during any raid and ask law enforcement whether there are things they can handle later during a grand jury subpoena. If law enforcement will agree to that, that can shorten the time that they're on site. So, you know, once legal's involved, they might be able to say, you know, we understand you want all of our accounting records or whatever it is. We're agreeing to provide all of those under a grand jury subpoena later. And you might be able to negotiate some things down as a result of that, if that's the kind of policy you have. You have to think through whether, if there's a request made for employees, will you go and locate those employees for law enforcement and bring them to the conference room or wherever they're operating for those interviews? That can minimize disruption, but especially in the immigration context, maybe companies decide instead to have a policy where they don't want to be involved in that. Again, something where there's not a right or wrong answer, but it's best to think it through beforehand rather than on the fly while all of this is going on. There almost certainly will be requests for documents and access to electronic information. Generally speaking, it's good to have an IT policy that talks about what steps are necessary for someone in IT to release information to a third party, including law enforcement. Those policies should be followed with the limit that, again, if law enforcement is standing there demanding access to something, it's probably not going to be a viable answer to say, you know, I have to follow this 17-step process to allow you to access our systems. If they're demanding it, there needs to be a workaround, but it's great, again, to have that planned at the outset. Generally, the access to documents is not the first thing that happens. You know, they'll interact with that first point of contact for a while. Maybe they walk through the facility for a bit. And so hopefully, to the extent there's some IT access policy, you know, IT can get notice from that first point of contact or as part of the escalation process, and then they can be ready to get access to law enforcement when they get to that point. We talked about who's going to accompany law enforcement and what will they do. You know, that accompanying person should understand the need to document what's being taken. Generally, law enforcement will give you a list at the end of a raid of what they took, an inventory, so to speak, but that inventory can be very, very high level. It might say, you know, we took HR records, as opposed to the person who's accompanying them could write down, they asked for the files of these 5 people. Obviously, when legal is later trying to figure out what law enforcement's goals are, what are they investigating, do we need to conduct an internal investigation, all of those questions can be informed by this more detailed list of what was taken. You should think through whether employees will be directed to not post about the raid on social media, not discuss it publicly. You know, do you want to have policies addressing that if any of these types of events happen? Also, for those managers and legal that are contacted as part of the escalation process, they want to be prepared to debrief immediately after departure on what happened. You'll have someone documenting what was taken and what witnesses were interviewed, ideally. But then, you know, this is a fast-moving situation. And so having that debrief at the end can allow the people who were involved to talk about what happened. If there are witnesses that were interviewed, it's appropriate to ask them if they're willing to share what they were asked. All of that is, again, going to help legal figure out what's really going on here. In combination with review of the inventory, review of the warrants and other documents themselves, legal can then decide what are the next steps. Do we need to conduct an internal investigation? Do we need to engage outside counsel to do that? Do we need to send a litigation hold for any information that's arguably in the scope of whatever it appears government agents are investigating? Is there further cooperation that's necessary with the government? Do we need to affirmatively reach out and give them something that they didn't take or provide information in response to a grand jury subpoena? You know, all of those things are sort of on this management and legal list of items to consider in the aftermath of a raid. So what about IT? IT should have a process, as we talked about, ideally, where you understand who the stakeholders are that can decide what to give to law enforcement or other third parties. And they should, you know, the IT boots on the ground should be trained to obtain those necessary internal approvals quickly for the release of those records. They should explain whatever those policies are to law enforcement. But again, if law enforcement says directly, you know, I don't care that you don't have your 5th layer of approval, give me access, they should also be ready to do that. Everybody's IT system is different. It has a lot of components. Often there's third-party providers of systems. They might hold data. There might be data in systems that don't really translate well, unless law enforcement had access to those systems, often called structured databases. IT should think through how they would go about giving access to all of those systems without sort of exposing the systems to more access than is being requested. In other words, we want to get law enforcement what they want, but we don't want to open a carte blanche of, you're asking for these 5 things. We also have these other 25 systems. Do you want those? There's not a legal obligation to go above and beyond like that and volunteer more information. So it's good for IT to have a plan to think about, how do we go about segmenting all of these systems and getting law enforcement what they need without giving them more than is necessary. If IT has back-end ways to preserve data, prevent deletion or modification, at least during the course of the raid, that's a good thing to think about doing. If there's something that is taken by law enforcement, it's a great step for IT to retain an actual copy of what was taken. Not just, obviously, you have that material on your system yourself already, but if you make a copy on a thumb drive or a hard drive or a forensic copy and give it to law enforcement, make a second copy. That's the easiest way for legal to see this is exactly what was taken. Maybe they need to look at that and say, law enforcement took attorney-client privilege materials and we need to claw those materials back, or maybe there's some other thing they can learn from that copy. It's just a good standard practice to have to make that copy, just to make sure you know exactly what law enforcement have. I have 2 questions in the chat about this. One is, what type of documents or files would law enforcement need from the company or IT? That's incredibly dependent on what type of investigation they're conducting. So, let me give you a couple of alternative examples. One might be an employee of your company committed a crime that isn't related to company business. So let's say, I'm just trying to think of something that would involve the computer system. Let's say there was some improper access to illegal material made through a company computer system. In that case, they might come in and say, we're investigating employee X's use of the computer system. So we want to fully image that person's computer network drives, whatever it is that person has access to. So you might need to fully image that person's information and give it to them. A more typical example in a company context, frankly, is they might be investigating some conduct of the company or some subsection of the company, in which case they're more likely to say, we need access to some shared drives or multiple computers or systems about, we're investigating whether there was a defect in your backup camera system, for example. And so then they might say, we need all the teams that have access to that information, the electronic data, or we want to run search terms across your systems to look for particular things. So it really can vary, and it makes sense for the company. Maybe this is legal, maybe it's compliance, maybe there's some other stakeholders in this kind of decision making, but whoever those stakeholders are, it makes sense for them to spend some time thinking through what some alternatives would be and how they would provide access to those systems. Another question we got is, do we need to provide access to our systems if law enforcement does not have a search warrant? So Mark's going to talk in the next section a bit about the differences between the types of process that law enforcement might have, but at a high level, there's a search warrant that permits them to access at least portions of the facility. There's an arrest warrant, which permits them to arrest a person, but doesn't generally come with that facility access. And then there's a subpoena that would be for documents and materials later. So the arrest warrant, you probably don't have to give access to systems. That's just not an issue in that kind of scenario, generally speaking. Subpoena is something that legal should handle later. So legal should make the decision about what you need to provide access to. And then in a search warrant context, that's where we're going to be fast moving and there could be a request for systems access. That's mostly what we're talking about. There is a possible but unlikely event that law enforcement might show up without a warrant. In some situations, they're allowed to access without a warrant, like if they have exigent circumstances. It's an emergency, I don't know, they saw someone shredding documents, or they saw a fugitive run into the facility or something like that. They can enter and potentially request access to systems. I guess that would be more in the shredding or deleting evidence situation. What we would recommend, again, this isn't, we can't give one size fits all advice in this kind of context, but the question you need to think through and answer for your company in that kind of scenario is, what's the escalation process? So they show up, they don't have a warrant. The first line of defense person asks who they are, what process do they have? They don't have a warrant. You follow the escalation process, presumably get to legal as quickly as possible, and then legal decides what kind of access to provide without a warrant. That's the most ideal situation. That way IT has guidance on what they can and can't do without a warrant. But again, you want to keep in mind that if this is somehow an emergency situation that's fast moving and federal law enforcement officers that are armed come into your facility without a warrant and demand systems access, the overriding thing needs to be safety, right? So in general, it would be great for the company to think through what happens in that unlikely situation and have an answer that make sure that employee safety is paramount, so that we don't want a situation where employees are resisting or obstructing justice or anything else that might separately be considered criminal. So what about witnesses? Law enforcement can ask to speak to particular employees, and the folks that are interacting with law enforcement and those employees should be trained on what to do and what not to do in that situation. So a couple of high-level do's and don'ts. Do always, be respectful and cooperative and not obstructive. Tell the truth in response to direct questions while not volunteering additional information. Always follow instructions from legal counsel, which obviously overrides anything we're talking about today. Don't destroy, hide, alter documents or evidence, speculate or guess, or otherwise obstruct agents, or as we talked about before, consent to some broader search. Anything they're voluntarily asking for, employees or witnesses should not be the ones deciding whether to provide that information. Those are all things that should come from legal or the members of that escalation process. So what about witness rights? Employees ideally should also be trained on their rights. They do have the right to decide whether to participate in an interview or not, legally speaking, and they cannot be retaliated against legally for that decision making. They have a right to counsel. That could be company counsel or individual counsel. And everyone, of course, has the Fifth Amendment right to remain silent. I like this cartoon because it talks about anything you say may be used against you in a court of law, but then also social media and any other technology yet to be invented. When we're speaking out in this kind of context, when law enforcement is involved, it could be something that's of public interest. And so, that right to remain silent doesn't just have to be about the courtroom. You can also the company can have policies that talk about strategic decisions about whether to speak or not to speak. Okay, I'm going to turn it over to Mark to talk about how you look at a warrant and what employees should know about that.
Thank you, Jen. And Jen, if you don't mind advancing the slides for me, I don't seem to have the control here. So, okay. So now Jen has kind of set the table for you. The people at the security or the reception area have received some sort of documentation. What is that documentation and what do you do with it? So I'm going to go through the types of documents that you may see in a connection with a dawn raid. The first one, the most obvious one, is a judicial search warrant. That's what is showed here in a federal context. When you look at it, you're not going to, many of you are not attorneys, and even if you are an attorney in an urgent situation like this, you're not going to want to fly spec it as far as their basis for probable cause, for instance, because frankly, you're not going to know. All you're going to get is this warrant itself. You're going to have an attachment behind it, which indicates the items that can be searched and seized, but you're not going to have the actual affidavit that supports this, that shows the probable cause. So that's not something that you're going to want to, you're not going to get likely, not for some time in the matter, and it's not something that you can certainly quibble about at that time. But you should look at some basic parts of the warrant to just see if they meet muster. Like for instance, you can see some of these the open spots here. They talk about the area to be searched. Here it talks about the location, the venue. Down further, there is indication of the items that are to be seized. At the bottom, there is a place for both the judge's signature. You want to make sure that it's actually been signed and dated by a judge. In there, there's a commandment as to when this search can take place. So ordinarily, there's a box here that says in the daytime between 6 a.m. and 10 p.m. That is a standard search warrant, and that's why dawn raids, they get together at around 5 a.m. at their separate location with the intent to get there right at 6 a.m. As early as possible. And their hope is to conduct that search and complete it by that full day. In a more complicated search that may involve, let's say, a larger facility and a dozen or more agents, they may be there all day, all the way up to 10 p.m. But if they go past that, and if they don't have a special authorization from the court to continue the search, then they're going to have to cordon off the areas and then come back the next day to complete the search. Usually they want to get it done in one day. So those are things that you're going to want to take a look at. What specifically is the address correct? There are situations, more in reactive cases or in state and local cases, where agents have on occasion gone to the wrong location. It's probably not likely in a white collar corporate search, but it can happen, and you should take a look specifically that they have the right facility identified. Maybe you have multiple facilities. Maybe they've gotten that wrong. They're only authorized to go to the place that is actually described in the warrant itself. If you see something, a discrepancy in the warrant, by all means, you can point that out to the agents that there is an issue here, but you should not bar the door from them coming in by virtue of that, because of what Jen said before. This is could be an exigent circumstance. You may get pushed to the side. You don't want to hurt yourself. Really, the agents are in more jeopardy than the company is if there is a significant mistake or fault in the warrant, and yet they continue to go forward. Later, a lot of that information that they seized may end up being suppressed because the warrant wasn't authorized correctly. So I would recommend that you point out where there are defects in the warrant, but don't then bar them from coming in for that reason. If it was an arrest warrant as opposed to a search warrant, you may see something different. You are not going to actually see the location listed, but you're going to see the identity of the person listed. Here, with an arrest warrant, they will have to have independent probable cause to enter the facility to find this person and perhaps to search them and their person. It may be something where an employee had committed a crime outside of the workplace. Frequently, those situations might involve, let's say, drug possession or distribution, child sexual abuse material. That may be a reason why the agents are coming in to arrest that person. They want to seize their devices that may have the child sexual abuse material on it. Or it could be an immigration case, or it could be a national security case. So take a look at the warrant, make sure that the things are on there. And specifically in the search warrant context, you want to make sure that maybe the entire facility is not identified in the warrant. Maybe it's only the administrative office that they're allowed to search, not the plant floor itself. Again, point that out to the agents. If they are going beyond the scope of their search and they are not entitled to go onto the plant floor, and yet they are going there, point that out to them so that you've made a record of it, and certainly record that in some fashion, either in your notes that they are going to a particular location that they wouldn't otherwise be authorized, or if you are filming them with your iPhone or something like that, film the locations that they're going so that you can later document that to your legal counsel, and they may have some abilities to push back on the agency at that point. An interesting point about can agents go in and seize records, especially electronic records, in connection without a warrant? I will just add that is a highly unusual fact scenario, but it could happen in an exigent case where, let's say, there's an active shooter who happens to have been an employee. Maybe they left the location where they were an active shooter and now they're hiding out in the facility. There may be reasons why the agents feel a sense of urgency to get into the facility without necessarily having a warrant on them. You're not going to be in a position to be able to question that, other than to ascertain their identity and whether or not they have a warrant. But again, you don't want to bar their entry because they may know things that you don't. It could be a national security case where there's exigent circumstances, or it could be something else where they know for maybe they don't care about whether or not they are going to be able to use this evidence later. It could be a national security case where they're gathering intelligence. So there's just a lot at play there. And other than asserting your objections and also ensuring that you are not consenting to their entry into these places, but you're going to cooperate, that's the kind of posture that you want to take. So next, we're going to go to a federal grand jury subpoena. And oftentimes at the end of a search, you will, when the agents are getting ready to leave, they serve a grand jury subpoena. Now, why did they do that if they've already gone in there with the search warrant? Is in part because they may not have captured everything. Maybe they didn't go to the right room that had the right materials. There may be any number of reasons why they do this, but this is more or less a belt and suspenders. Up to this point, they haven't subpoenaed the company because they've been operating covertly. They have not wanted to tip off the company that they were coming in, but now the company understands that they're under investigation, or at least some of their employees are under investigation. And so the search warrant is basically their ability to gather any information that they otherwise didn't get. When you look at the grand jury subpoena, it will be directed to the custodian of records, so the person that maintains the records, and it will be for a combination of testimony and records. They will demand that the custodian appear at a particular location, a grand jury location, usually in a federal courthouse, and then bring the records with them and testify if necessary as to the records themselves. Usually what ends up happening in cases like this is the custodian will sign a waiver and a certification that the documents have been retained in an appropriate manner that would allow them to be admitted into evidence as a business record. And then the agents will dispense of the requirement that the custodian actually come and testify in court. And again, with the subpoena, this is probably something, it won't be as exigent. So this is something that you can coordinate with your legal counsel. They will look at it. They will probably confer with outside counsel and figure out the best way to proceed and when to get the records to them, negotiate the scope of the subpoena, maybe even the timing of it. It's important to note, though, if this is the only document that you receive is a subpoena and you don't receive a search warrant, the subpoena doesn't authorize entry into the facility. It is only a demand for documents. Okay, we did talk about administrative and ICE warrants. This is kind of a hot topic now. There are certain warrants which a judicial officer does not sign. They're called administrative warrants. Different agencies use them. ICE is right now in the news in connection with the administrative warrants it uses. And oftentimes the warrant itself will say that it's an authorized immigration officer that is signing. that finds the reasonable suspicion or the probable cause in this case. It won't identify a specific location. It is usually to identify somebody, an illegal alien that is extended past there is a final order of removal for them, and the agents are trying to find them. The legality of this is a subject of hot debate right now, both legally and politically, as to whether agents can enter into private residences or private spaces in order to find the particular person. It's been longstanding for use of these in civil process, for civil immigration arrests in public spaces. And historically, most people have considered it to be a Fourth Amendment violation to actually enter into a private space in order to execute this. But recently, in January of this year, it was revealed through a leak that the acting ICE director had issued a memo authorizing ICE agents to use necessary and reasonable force to enter residence to arrest individuals with final orders of removal, using only these administrative warrants. There are legal challenges to that. It's working its way through court. We don't know what the final disposition of that is. So the bottom line is the issue is in flux. So if you get an administrative warrant, you can politely object to access, but if they demand entry, it's best just to cooperate, do not interfere, but do not consent. One of the questions, and Jen alluded to this before, is, okay, well, they come with this administrative warrant. They're in the public space. They're in the front reception area, and then they demand to have the person who is identified in the warrant brought to that public space from the plant floor, the administrative offices, or whatever, and brought for purposes of the arrest. That is going to be a policy decision that you're going to want to make as a company as to how you want to go forward with that. Do you want to bring the person forward? Do you want to risk that, well, that they may just enter themselves anyhow and come to your facility? Those are things that you are going to want to think about in advance and talk with legal counsel to make sure that you have a set policy in place. Okay, the next immigration issue that has been of interest is the idea of warrantless searches near the border. Immigration officers at the border have authorities for search, seizure, and arrests, increased authority that they don't have in the rest of the United States, just by virtue of the fact of the border and protecting national security. The question is, though, how far does that border extend? Is it just at the customs station or the border entry, or does it extend further? And there are specific statutes that allow immigration officers, and they have to be immigration officers, who are preventing the illegal entry of aliens. They are entitled to go on private lands, but not dwellings, within 25 miles of the border. And so by the border, that could be the coastlines, or that could just be the border of the country itself. And many of your facilities are probably located within 25 miles of a border. For vehicles, there is an exception to the warrant requirement for the same circumstances within 100 miles of the border. So an immigration officer could enter into a vehicle in search of an illegal alien within 100 miles of the border without a warrant. One of the questions is a facility, a commercial facility, considered to be a dwelling? Because a dwelling still requires a warrant even within 25 miles of the border. This is an open question. The regulations suggest that a commercial facility may not be a dwelling, but historically, most people have considered under the Fourth Amendment commercial facilities that are not open to the public to have a reasonable expectation of privacy. And so it's a question that remains out there. The current administration has taken a fairly expansive interpretation of the immigration laws. So particularly in the southern border, there is a possibility that they will interpret a commercial facility as within 25 miles of the border as a place that they can enter without a warrant. That is something that you'll have to kind of take up after the fact if something like that was to occur. but it's not something that you're going to be able to answer on the fly if agent happens to knock on the door. Administrative warrants, the best practice, if a circumstance like this happens, is to politely object and not to consent to their entry to the facility, but not to interfere. These matters can be litigated later. Okay, now we're going to talk about how to prepare for dawn raids. And Jen had alluded that that part of this has to do with not just having a policy, but practicing that policy so that you are comfortable with what to do going forward. We can advance to the next slide. So you want your first responders, the people that are the security officers or the reception area, to know what to do in a situation like this of a dawn raid and how to handle that initial encounter until legal counsel can help out and help coordinate. And that means that what managers do they contact at the earliest opportunity? How do they coordinate with the information technology staff who are inevitably going to become involved in something like this? And what to do with the employees and their rights, the things that Jen had told you about before. Many companies have a cheat sheet, like a one-pager, sometimes a two-pager, or a reference guide that is available at the reception area and for all of the security officials so that they know exactly what to do and who to contact so that they don't have to memorize that. But periodic training, including tabletop exercises to kind of map these things out, are very useful so that people are comfortable with their role and hopefully without breaking your back in the process. Okay, so this concludes our presentation for today. We have about 8 more minutes, so if there are any other questions, feel free to add them to the chat. We are happy to answer them.
So Mark, I don't know if you saw, we did have 2 questions in the actual Q&A that were provided. I'll go ahead and read them out to you. One of them said, do we need to provide access to our systems if they do not have a warrant? And if so, what type of document files would law enforcement need from the company or IT?
Yeah, Jen was actually able to answer those
Okay,
during the process. Yep, so we've covered those 2. If there are any other questions, we would be happy to answer them. Okay, if we can just advance to the last slide. Here are the email addresses for the presenters, Jennifer Beidel, myself, and Sarah Douglas. We're more than happy to answer any additional questions that you might have or you might consider over as you think about some of these issues related to your company. And with that, I thank you very much for your participation, and we look forward to talking with you all soon.